Hi, welcome back. In the previous video, we talked about software defects that are rarely lethal and the number of injuries and death is now very small. Software, however, is now the principal controlling element in many industrial and consumer products. Most companies are in the software business whether they know it or not. The question is whether their products could potentially cause damage to the public and what their exposures be if they did. Software product liability, or commonly referred as product liability, is the liability of the manufacturers, sellers, lessors, and others for injuries caused by defective products. If a software defect causes injury or loss to purchasers, lessees, or users of the product, the injured parties may be able to institute legal proceedings against a person or institute as a result. Injury or loss can come in the form of physical mishaps and death, loss of revenue, or an increase in expenses due to a business disruption caused by a software failure. To sum up the thought about the product liability, it is the area of law in which consumers can bring claims against manufacturers and sellers for products that injure people. When speaking of law, the government conforms to the interest of consumer and the public relating to product quality. In the Republic Act of the Philippines numbered 7394 of 1992, the Act protects the interests of the consumer, promoting its general welfare and to establish standard conduct for business and industry. For specific details, refer in the Chapter 1, Article 5 for consumer product quality and safety. Strict liability means that the defendant is held responsible for injuring another person, regardless of negligence or intent. The plaintiff must prove only that the software product is defective or unreasonably dangerous, and that the defect caused the injury. There is no requirement to prove that the manufacturer was careless or negligent, or to prove who caused the defect. All parties in the chain of distribution, the manufacturer, subcontractors, and distributors are strictly liable for injuries caused by the product and may be sued. Defendants in strict liability action may use several legal defenses, including the doctrine of supervening event, the government contractor defense, and unexpired statutes of limitation. Under the doctrine of supervening event, the original seller is not liable if the software was materially altered after it left the seller's possession, and the alteration caused the injury. So to establish the government contractor defense, a contractor must prove that the precise software specifications were provided by the government, that the software conformed to the specification, and that the contractor warned the government of any known defects in the software. Finally, there are the statutes of limitation for claims of liability, which means that an injured party must file suit within a certain amount of time after the injury occurs. Negligence is a failure to do what a reasonable person would do, or doing something that a reasonable person would not do. When sued for negligence, a software supplier is not held responsible for every product defect that causes customer or third-party loss. Instead, responsibility is limited to harmful defects that could have been detected and corrected through reasonable software development practices. Contracts written expressly to limit claims of supplier negligence may be disregarded by the courts as unreasonable. So, software manufacturers or organizations with software-intensive products are frequently sued for negligence and must be prepared to defend themselves. A warranty assures buyers or lessees that a product meets certain standards of quality. A warranty of quality may be either expressly stated or implied by law. Express warranties can be oral, written or inferred by the seller's conduct. For example, sales contracts contain an implied warranty for merchantability, which requires that the following standards be met. Refer to the slide. If the product fails to meet the terms of its warranty, the buyer or lessees can sue for breach of warranty. And for the international misrepresentation, it occurs when a seller or lessor either misrepresents the quality of the product or conceals a defect in it. We have many types of representations, such as advertising, salesperson's comment, invoices, shipping labels, etc. Most software manufacturers use limited warranties and disclaimers to avoid any claim of misrepresentation. Read the book Information Technology for more details.